Custody modification lawyers. It would be wonderful if a divorce or child custody case could deal with all the resulting issues until the children reach adulthood. Unfortunately, that is not always the case. Lives evolve after people go their separate ways. Often what the court ordered at the time of the divorce or child custody case is no longer practical. Long after your divorce lawyer finished the divorce, you may find the need to modify the current orders. The Texas Family Code provides opportunities to modify the terms of the court order to rearrange custody and child support. Modification suits can be complex. Often they are even more complex than the original divorce or child custody case. An experienced family law attorney can help you pursue a modification of custody rights and child support. Child custody modifications in Texas. After the court issues child custody orders affecting parental rights and parenting time, visitation, it may become necessary to modify those orders to change rights, duties, and schedules. Although parents are free to informally agree to deviate from the order, when the parents cannot agree on changes, then the court has to formalize changes in a modified order. Under the Chapter 156 of the Texas Family Code, a court can modify a custody order when there is a meaningful change in circumstances since the last order. That change in circumstances can include a change in the life of one or both parents, a change to the child's needs, or a change in the co-parenting relationship. The Texas Family Code provides specific circumstances that permit the court to find a change in circumstance justifies a custody modification. If you believe modifying the existing order is necessary, then you should talk to a custody modification attorney in Texas. Section 156.101 of the Texas Family Code identifies the 3 conditions that permit your custody modification attorney to file a motion to modify a custody order. A material and substantial change in circumstances. A child aged 12 or older tells the judge the child wants to live with a different parent. The custodial parent relinquished custody for at least 6 months. Material and substantial change in circumstances. Most custody modifications in Texas fall under the material and substantial change in circumstances. Although the Texas Family Code does not specify the exact situations that create a material and substantial change in circumstances, your custody modification attorney can advise you on the probability that your judge will consider your circumstances sufficient. Some of the circumstances Texas judges often find sufficient include: the death of one of the parents. A parent marries a new spouse. A parent suffers a debilitating injury or illness that significantly affects that parent's ability to work or perform child-raising tasks. Criminal convictions of a parent. One of the parents relocates somewhere that causes hardship to the child or the other parent to exercise visitation. The facts of your individual situation will determine whether a material and substantial change exists. Judges generally will not modify an order if there have been slight changes in circumstances or a minor inconvenience to one of the parents. Child's preferences. Generally in Texas child custody cases, the judge does not want to have children in the courtroom unless absolutely necessary. In this situation, the judge has little choice. The Texas Family Code permits modifying a custody order if a child of 12 years of age or older wants to live with the other parent. To satisfy that requirement, the judge must interview the child in chambers. The judge must also find that changing the custodial parent is in the child's best interests. Changing the custodial parent often will require modifying the conservatorship rights between the parents as well. Relinquished custody by the custodial parent. The third reason a court can modify a custody order is when the custodial parent relinquishes custody to the other parent for 6 months or more. If the custodial parent has voluntarily turned over the child to the non-custodial parent for half a year, then it often makes sense to allow the non-custodial parent to legally assume the role of custodial parent. This does not apply if the custodial parent relinquished custody to the other parent due to active military deployment or duty. Note, however, that this is specific to the custodial parent relinquishing custody to the non-custodial parent only. The custodial parent has the right to designate the primary residence of the child, which can be with a non-parent. The custody order permits the custodial parent to make that decision. However, there may be circumstances in which that could constitute a material and substantial change in circumstances. This is a good reason to talk to a custody modification attorney. Filing a custody modification in Texas. Filing a custody modification usually requires returning to the court that issued the custody order in the first place. A motion to modify the custody order has technical requirements depending upon the reason for the request and the time since the last order. Depending upon the reason to modify, certain allegations must be raised explaining the basis for the modification. Effectively, the modification creates a new custody case. There may be temporary orders issued, discovery, mediation, and even a trial. Modification lawsuits can be more challenging than the first case. In the first case, the judge could rely upon basic solutions like ordering the standard possession order. In a modification, the petitioner must assert a failure of the existing order to provide for the child's best interests. As a result, the parties often must present more evidence, and the judge may insist on experts to assist the judge in coming up with a new order. Modification suits can quickly become complex, costly, and frustrating. An experienced custody modification attorney can help you navigate this process and present a case that supports your relationship with your children. Often when parties file a modification without attorneys involved, the judge is more likely to require expensive professionals to participate in the suit and help the judge decide the case. By not hiring an attorney, you may not save any money but lose the opportunity to have an experienced advocate on your side. Child custody enforcement hearings. Often before a parent decides to file a modification suit, there have been problems with the custody rights or visitation schedule. One parent may not follow the requirement in an order to cooperate on medical decisions, or a parent may refuse to follow the visitation schedule in the order. A parent may ask the court to enforce the existing order either before requesting modification or along with a modification suit. An enforcement proceeding asks the court to order the other parent to comply with the existing order and may penalize that parent to force compliance. Sometimes it is desirable to enforce compliance with the existing rule before or during a modification suit. Your custody modification attorney can talk to you about the best approach in your case.